B, why don't you come on up, from B. Edwards from the Government Accountability Project. It'll take just a second to get some slides organized as we go.
Mm-hmm. There we go. So I just hit down. Well, it's kind of difficult to be the following speaker after Eileen, but I did want to tell you a little bit about my organization in the United States. I'm the director of the Government Accountability Project, and we are a whistleblower protection organization in Washington. We operate as a law firm and as a non-governmental organization, so we work on policies too. Excuse me. We were founded in 1979 in the wake of the Watergate scandal in the U.S., which, if you recall, occasioned the resignation of President Nixon. In the aftermath of that scandal, it occurred to a couple of lawyers working in Washington that there were people in the administration, in the White House, in the Department of Justice, who wanted to speak out at the time and talk about what was happening, but who couldn't do so safely because there were no laws to protect them, and they would have been subject to the most ferocious retaliation. Clearly, even people who didn't speak out were subjected to retaliation and reprisal. And so two lawyers started working in the United States in 1979 to found the Government Accountability Project and to establish a law to protect whistleblowers. And that law was finally passed in 1989, so it was 10 years before we had any law that protected even federal government whistleblowers officially. The effectiveness of that law is questionable even now, but it is in effect, and it does give us a hook to work with as we try to protect whistleblowers in the federal government. I wanted to talk this morning, though, about international whistleblowers who are in an even more precarious position than whistleblowers who are operating in a national context. So I'm going to talk about three cases that we had at GAP. Beginning about 2005, we started to represent whistleblowers who were talking about misconduct, wrongdoing, fraud, corruption at the international level, and found themselves without any kind of protection or defense. And these are whistleblowers who come to us from the intelligence community, the national security apparatus in the United States, from international organizations like the United Nations, the World Bank, the Inter-American Development Bank, et cetera, and from corporations that operate internationally. All of these kinds of institutions play a shell game with whistleblower protections. That is, they move from jurisdiction to jurisdiction, and they hold up any kind of anti-retaliation measure in endless administrative proceedings until the whistleblower can no longer fight them. So I'll talk first about these three cases, the disclosures and the issues raised. The first case is Edward Snowden. Edward Snowden is a GAP client. We represent him in the US legal system on issues that don't pertain to the criminal case against him. He is, as you know, an employee. He was an employee for a contractor of the National Security Agency. He exposed mass surveillance, and he raised an important question in the international context. That is, what happens when the security demands of one country conflict with the sovereignty of other countries? And this is a question that came to me in the aftermath of his disclosures when some of us were having a teleconference among NGOs that protect whistleblowers. And someone asked in that teleconference what the impact of the Snowden disclosures were. And as an American citizen, I started talking about the constitutional issues that Snowden's information brought up, that he was exposing activities taken over many years that violated the Constitution of the United States. The First Amendment, which protects free speech, the Fourth Amendment, which protects freedom of association, and the Fifth Amendment that protects us from self-incrimination. And so in the framework of national law in the United States, Edward Snowden was reporting that the government of the US was guilty of crimes. So our German counterpart, who was on the phone then, said to me, so what you're telling me is that it's not okay for your government to spy on you, but it is okay for your government to spy on me. And I really didn't have a ready response for that question, really. The only thing you can say is, well, define okay, because it's clearly not okay for the government of the United States to spy on the citizens of other countries who are not suspected of a crime. But legally, there isn't any defense or any remedy for that practice undertaken at the international level. And the other question Snowden raised is, does one country have the right to subject the citizens of another country to actions that would be illegal in the country taking them? So here we are again, the US government is spying on innocent people, but this would be illegal in the United States, but it's not illegal internationally. And that left Snowden in this no man's land. He was reporting crimes taken by the government of the United States in the United States, but he was also reporting things that the government of the United States regarded as legal. And in that sense, people who would have defended him in the US were saying, we can't defend him because he isn't a whistleblower, he's a traitor, and he has revealed national security practices that should never have been revealed under the laws of the United States. And I'm not going to talk too much more about the Snowden disclosures. Everyone's familiar with them, and we've talked about them a great deal. In another context, whistleblowing is even more complex. We have the case of a woman named Aisha El-Basri at the United Nations. You think of the United Nations as this kind of benign organization that brings the voice of reason to conflict situations around the world. In reality, the United Nations is a composite of governments, and it operates in a highly politicized environment. It's very difficult to negotiate the internal procedures of the UN. And whistleblowers there find themselves in a lot of trouble very quickly if they expose anything that is happening internal to the organization that the organization would be embarrassed by. So El-Basri reported, she was a spokeswoman for the UN mission in Darfur, and the party line on Darfur at this point is that the conflict has been abated. The UN peacekeeping forces are there. And compared to what was happening, say, 5-6 years ago, the situation is somewhat pacified and the UN has it under control. El-Basri, as the spokeswoman for the UN peacekeeping mission there, which operates in conjunction with the African Union, found that she was being told to tell the press things that were patently untrue, and that the UN was attributing to insurgent forces atrocities, mass killings, mass rapes, attacks on non-combatants. These were being attributed to insurgent forces when in fact they were being perpetrated by the government and the military forces of the government of Sudan. So she tried within the UN to get this addressed, and it wasn't. And she resigned her post, I think in 2013, after serving for about a year. She had to finally go to the press itself to find some kind of platform from which to speak, because the UN had bottled up the truth about what was happening. And she was dealing with a situation in which national crimes were really crimes against humanity. They were crimes that needed to be addressed in the forum of protection of human rights and not in a national forum. The government of Darfur and the government of Sudan were obviously not going to deal with what was happening because they were the perpetrators of what was happening. And the UN was dependent and is dependent on the goodwill of the country where it's operating in a peacekeeping capacity in order to stay in the country. After al-Basri's allegations were investigated by the UN, the government in Khartoum asked the UN peacekeeping forces to leave. And that's what's being negotiated now. So her disclosures raise this question: who's responsible for crimes against humanity if we can't go to a national government and we can't go to an intergovernmental organization? And the final case that we represent at the international level that I was going to talk about is a whistleblower named Ben-Artzi. He worked for Deutsche Bank in New York and Berlin. He was what's called a risk management analyst, a quantitative analyst. He's a mathematician. His disclosures are very complex and involved, but he went to his superiors prior to the financial collapse in 2008, in September of 2008, and told Deutsche Bank that the bank had assumed more risk on the investment portfolio it was holding than it could redeem with the capital assets that it held. So that in blunt terms, Deutsche Bank was at that moment technically insolvent. And the bank was concealing this from its shareholders, from its board, and from its investors. And of course, we all found out in September of 2008 the degree to which major financial institutions around the world are interconnected, so that if Deutsche Bank is insolvent, so is Citigroup, so is Bank of America, so is JP Morgan Chase, because if one bank goes down, the assets of the others are virtually worthless. And in the end, in the US, the taxpayer had to bail out the Wall Street financial institutions to the tune of nearly $1 trillion. Ben-Artzi had reported this internally to the bank prior to the collapse, and he lost his job through a protracted series of retaliatory events. He's been blacklisted and has very, very few prospects for future employment. But he raised the question, how does a national law enforcement agency investigate multinational banking fraud? It was impossible. The mechanisms aren't there. And what is national jurisdiction is responsible for international financial crimes. We talk about, in retrospect, at least in the US, what happened in 2008 as a financial crisis, but really it was a financial crime. Everything that was done by the financial institutions that brought about the collapse, and the collapse did occur. We talk about it as nearly occurring or being narrowly avoided. It wasn't avoided, it did occur. And it was a result of assumption of risk in sophisticated securities that were sold to investors under false pretenses, and the people who sold them knew exactly what they were doing, and they knew what the consequences could be. They simply hoped to avoid the consequences, and they padded their own compensation packages in doing that. So what happened to the whistleblowers, and how can they be protected? Well, we know what happened to Snowden. He's in exile in Russia at this moment. It's worth talking about a little bit the Espionage Act, which was used to prosecute him. He's been charged but not indicted. There is not, so far as we know, a grand jury investigating Snowden or his disclosures. But the Espionage Act of 1917 is a 100-year-old law. It was passed in the heat of World War I because Americans were paranoid about what German citizens might do on behalf of their home country. And so the law was developed to go after spies, not whistleblowers. And as a result, it's a very blunt instrument to use against a whistleblower. As we saw in the Manning case, the Bradley Chelsea Manning case that preceded the Snowden disclosures, Manning could not present in a military tribunal a public interest defense. A national court wouldn't entertain a public interest defense either, so that the person being prosecuted couldn't say, well, it's true, I revealed classified information, but the classified information in turn described a crime and that the public had a right to know what its government was doing. There's no public interest, there's no affirmative defense that the defendant can use. The government need not show harm either. If you reveal, the government can classify embarrassing information, make it secret, and then if someone reveals that information, the government is not obliged to demonstrate in a court that there was harm done to the national security of the United States. In the Manning case, the government began to do some kind of assessment of the harm that was done by the public exposure of the Afghan and the Iraq war logs, but it never finished the assessment. It never presented any assessment of what harm was done by Manning. Nonetheless, he was subject to more than 3 decades of incarceration. That's the penalty that Snowden would also face if he returned to the United States. The trial proceedings under the Espionage Act are largely secret, so the press would not have access, nor would the public. We saw from what happened in the process of Snowden's detention or being stranded in Russia that allied governments would not protect him, and as a result, he's in exile. Aisha al-Basri was terminated. She's blacklisted for further work. She has no labor rights at all. International organizations have legal immunities from all national laws. They enjoy the immunities that an embassy in a foreign country enjoys. But unlike embassies, which are subject to their own national legal regimes, intergovernmental organizations are not subject to the laws of any country. Therefore, a whistleblower there is bottled up in internal administrative tribunal proceedings that are secret. They take, on average, 3 or 4 years to be processed. In the meantime, no press is allowed, no public disclosures are made, and by the time the whistleblower gets through this administrative proceeding, the world has moved on, nobody cares anymore, the whistleblower has been devastated, and the issue is gone. So, and that is what is happening to Aisha al-Basri right now. Ben-Artzi was terminated and blacklisted. He has a civil suit against his employer. He's tried to make use of the reforms that were passed under the Dodd-Frank legislation in 2010. These are largely inoperative, and again, they take a long time to wind their way through the courts. So what we see from international scale whistleblowers, these are not trivial disclosures. They're crimes against humanity. They're civil rights violations on a mass scale. They're financial frauds that are capable of bringing down the capitalist system. And if we didn't have whistleblowers in these various organizations, we would never have known that these things were happening. The effects of the retaliation are potentially long-term incarceration, marginalization, such as Ms. Chubb explained, professional ruin, physical danger, etc. And there are very, very few avenues open for any kind of protection or compensation. What you should see from some of these cases is that our best shot at protecting these people has been through the press, not through the courts, and not through legislation. It is the press that has protected Edward Snowden best. It's the fact that El-Basri went to the press and publicized her disclosures. That created a bubble of safety around her. The higher her profile, the more difficult it is to attack her. And the same with Ben-Artzi. The Financial Times exposed what was happening to him and has kept something of a spotlight on him. At GAP, then, what we try to do with cases like this, as time passes, is to keep them in the public eye so that people don't forget the whistleblower. There are many, many organizations that focus on the disclosure, that are concerned about civil rights violations and human rights violations and financial fraud. But lost in the shuffle is what has happened to the person who brought these crimes to the public attention. It's also the case that we don't want to live in a society that depends on whistleblowers for knowledge about crimes of this scale. When we depend on individual people, we're asking a single person to go up against a system, an entire institution, a federal government, a multinational corporation with very little protection and very few resources. So in that kind of a battle, the individual is going to lose. There is absolutely no way a single person can do battle with Deutsche Bank or the United Nations or the government of the United States. And therefore, what we need are credible, non-governmental organizations working together, working with the press, working with the public to defend not just not just address the crimes exposed, but to defend the whistleblower as time goes by. And we are making progress on this front. We established some time ago the Whistleblowing International Network. We have an executive secretariat and a steering committee. These are the organizations on the steering committee: GAP in the United States, ODAC in South Africa, Public Concern at Work here in the UK, Commonwealth Initiative for Human Rights in India, FAIR in Canada, which has fallen on hard times, Center for Human Rights in Chile, and Whistleblowers Netzwerk in Germany. And working together, the way WIN works is that if a whistleblower goes to a non-governmental organization in a particular country and that NGO is unable to protect the whistleblower effectively, that NGO contacts the network and asks for the technical expertise or the resources to help protect that person. The one case I wanted to mention where we managed to act quickly and effectively was a case of an IBM whistleblower in Ireland who had blown the whistle on misconduct in this international corporation. They charged her criminally with stealing 2 flash drives. And this is something that happens. When a whistleblower goes public, the press is often asking for proof, for documents. If the whistleblower, however, takes documents from a private employer, they can be charged criminally with theft. the IBM added an additional wrinkle to that. That is, they charged her with the theft of 2 flash drives, and she'd only taken 1. So she returned the 1 flash drive, but she couldn't return the second one because it didn't exist. And so they could, under the laws of the country, incarcerate her pending the return of this second flash drive. The NGO, which was Transparency International in Ireland, called GAP, and we have a legal expert on this kind of criminal proceeding who intervened immediately to exonerate the whistleblower and mitigate the circumstances so that there was time to mount a legal defense for her and avoid incarceration. What the network is trying to do is to organize then whistleblower protection organizations. We work together with networks of journalists, technologists, and lawyers, and all groups met in Amsterdam in June of this year to establish an action plan. So this is where we are, and this is why I'm here. I wanted to make it clear that if national level whistleblowers are in danger and are facing the kind of retaliation that Eileen talked about, international whistleblowers are even more exposed. And the crimes that they reveal are appalling. When El-Basri came to us to tell us what was really happening in Darfur, which has slipped out of the news over the last few years, it was astonishing that no one was doing anything. And when we realize how much we depend on these single people to tell us about crimes of this scale, so now, say, thanks to Snowden, we know what the NSA is doing. Somewhat, but since he left the NSA in 2013, we're not sure what they're doing since then. Since Aisha El-Basri left the UN mission a year ago, we don't know what's happening in Darfur. We don't know what's happening in Somalia or the Democratic Republic of Congo or Haiti. We can't be dependent on single individuals, and so there are 2 things we have to do. We have to begin to establish mechanisms that are more systematic about international regulations and a way to address international crimes. And we have to protect whistleblowers where they are when they face retaliation that is ruinous personally and professionally, so that in the interim more of them come forward. Thank you.
Thanks. We have some time for questions. Just a few announcements. One of them is that we have a special guest who's coming in this very area of whistleblowing, and hopefully he'll be here fairly soon. I'll let you know when he arrives. He's probably the best known whistleblower in the United States, and we're very pleased to welcome him when he comes. Yeah, go ahead. What? Maybe there's some questions. Well, we're getting to that. That's right. I think we can now take questions. Thank you. Sorry. Yeah. Right over here. We'll take that one down. That's fine.
Thank you. My first question is about international, my one question is about international whistleblowers. And I'm asking because until a few months ago, I also used to work with the United Nations in Iraq. One pressure, one thing we always discuss, I'm aware of the bureaucracy and the difficulty and how international NGOs and the United Nations is sometimes caught in this pickle where they have to tiptoe around local governments so the local governments would allow us to stay and work. But one thing that me and a lot of friends very frustrated with just slow bureaucracy and everything is if there was a means to put pressure on local governments by international donors. So let's say if the American government and American aid fund was, say, funding something in Iraq, they would put a condition as a result of a whistleblower, or let's say in Darfur, where they would put a condition to say, these are the transparency practices we want as a donor. This is how you will report your spendings. This is the overhead you can put on staff salaries. This is what we want you to do, or we're not donating millions of dollars for this aid. And I'm just wondering if you think that there's a way of also making this happen through your network of whistleblowers, because at the end of the day, the point of blowing the whistle is to make things happen, and we're not going to affect the policies, let's say in Sudan or Iraq, that way, but money definitely does an influence.
B, if you want to come up, sorry, we only have one microphone, so if you want to use this one, jump over, huh? Well, she can speak from here, right? Yeah. Ah, there we are. Okay, go ahead.
That's a very good question, because in fact, in the U.S., we did exactly that. GAP works through the Congress, through the courts, and through the press. So when we realized the situation that was occurring in the UN, we went to the Congress, and the Congress conditioned the U.S. contribution to every UN agency, fund, program. 15% of the U.S. contribution, and the U.S. is the biggest single donor, to the UN is conditioned on the effective implementation of best practice whistleblower protection measures. And the Congress will not release, according to the law, will not release the entire contribution to the UN until the Secretary of State certifies that these whistleblower protection practices are implemented. So John Kerry sent a report, John Kerry, the Secretary of State, sent a report to the U.S. Congress in August certifying that every UN agency, fund, and program was implementing best practice whistleblower protections. Although the content of the report he gave was patently false. They are not implementing best practice whistleblower protection. They have the policy, but they don't implement it. We went and we met with the congressional offices that are responsible for dispersing the funds, and they said, well, if the Secretary of State certifies it, we have to go ahead and release it. And the State Department in the U.S. certifies the most preposterous things. During the Central American Wars, the State Department certified there were no human rights abuses in El Salvador, in Nicaragua. So that's where we are. And that's why we're back to the press. The press then has to pressure the government to pressure the executive agencies to hold the UN to account.